And we've talked a little bit about some things in contracts. So I wanted to sort of next kind of jump through some important things with contracts. So when do you need a contract, okay? If you're transferring those copyrights, not just selling the artwork, you're selling the rights that go with that artwork, there has to be a contract in writing. If you're doing a commission agreement, now there's one thing if it's just like a private collector. I think you just, you could look at something that's, just sort of like payment terms, deadlines, purchase price, subject matter size, things like that. That can be very simple, but you do want something with that collector. If nothing bare minimum, please have something that in an email, right? And recorded in an email. But if you're going to be doing a larger work, like if you're going to be doing something for the city of Dallas, they're going to send you a contract, right? Most companies, if you're doing more larger corporate works too, they're going to send you a contract. Collaborations too, if you're collaborating with a brand, right? There's going to be, say you're collaborating with a shoe company, clothing company, interior design companies, and you're going to need an agreement that discusses sort of the artwork that's created and how that collaboration will work. And then also the rights, with the copyrights. Who's going to get that? Are you keeping that? What's your payment, your royalties? If you're going to license the artwork, similar to collaborations as well. So licensing is meaning you're still keeping the copyrights, but you're just giving someone permission to borrow those rights for a particular purpose, maybe a particular time frame for a particular thing. You want that scope of what is being, the permission, they have to be really, really clear. Freelance contractor work, I definitely think you want to have a contract with that. That also talks about, the scope of your work, how you're getting paid, specifically a lot with commissions too, the timing of the sort of the deposit. I always tell my clients, if you're getting paid in increments, try to get as much upfront as you can as possible, and the first payment as big as possible, right? Because that's going to cover your materials, and then if there's anything, let's say they get late on payment afterwards, you don't want, and maybe you've got a friend helping you create the work or things like that, and you've got to pay them. You want to make sure you've got enough in that first payment to cover you and cover your expenses, so that if they shortchange you, you're not really having a financial struggle at that point. I definitely want that sort of the freelance contractor work, and there's going to be discussion making sure that either you're keeping those copyrights or are you transferring those copyrights. Exhibitions and gallery representation agreements. Galleries are more now requiring these and presenting these contracts now, so that has changed. I think that's going to continue to change. I rarely actually hear people working on handshakes anymore in the gallery world. Now, the quality of the contract you're going to get is something that they come in all shapes and sizes. So, but there should be, you want that too, because you want to know the expectations of what's the cut a gallery is going to get. What's the expectation? What are they going to do marketing-wise for you? What's the expectation of how many shows you're going to have? Are you allowed to do online sales without and get all that money, right? And the gallery not get that? That's a new thing. So a lot of artists are keeping those rights for their online sales that are done through their website and through their Instagram versus the gallery, right? So that would be really good to always have looked over as well too. Performances and art festivals, participation in that. There's usually going to be a contract, and then renting a studio, your leases. You'll have a lease agreement. You should have a lease agreement from your landlord that states how long the lease is and rent and things like that. Okay, contract misconceptions. We're both honest people, and a handshake's good enough. I've seen so many relationships start out in such a loving and collaborative manner, and things change over time, and things break down, and both sides are hurt. So you should not be afraid to say if I want a contract, that other person's not going to want to work with me because they think I'm being difficult. And that's not the way things work anymore. It's very professional of you to ask for a contract and to say, look, I want to make sure that you're protected and I'm protected and we know what each other is doing. And if you hear from someone, they say, no, well, what, do you not trust me? That's a red flag. that's a red flag to me, because the contract is to help both people. It's to really discuss the rights and obligations both parties have, okay? So when I hear that someone says, well, why do you want to do that? You don't trust me, that's a red flag to me, okay? Or I've never done that before, so I do, right? This is what I do. You're the artist, you are the creative, the artwork does not exist without you. So please know that you are empowered and that you should be asking for these things. Contracts are long and complicated, I'll never understand them. Yes and no. They can get overly long and complicated, like that silly clause I had up there that was absolutely everything. But I've written that same thing in 3 sentences, right? So it can be, a contract doesn't have to be it's got to be clear. And you have to think of, okay, if some random person I don't know that doesn't know me or the other party to the contract, would they be able to pick it up and read it and understand? Do they understand what kind of artwork I'm creating? Do they understand what I'm supposed to get paid? Do they understand the due dates? Is it clear to someone else when they read this? And that doesn't have to have legalese. That can be, just drafted, just very clear, matter of fact language. Even though the contract says something else, we've agreed verbally to something different. So that was the example I gave with the photographer. Most contracts have this clause at the very end. It's called the entirety clause, or it's also called an integration, but it'll say entire agreement. And then it says everything in this contract is the entire agreement of the parties, and nothing outside of this contract, whether verbally or otherwise, written down, matters. Contracts are a ticket to a lawsuit. I think contracts prevent lawsuits. The situations that most likely go to a lawsuit is when it's like, someone said this, someone said that, or we agreed to this and we agreed to that, and I'm literally going through all these like text messages and emails to cobble something together, because all those text messages and emails are evidence. And that's, if I don't have a written contract, I gotta okay, well, what were they thinking? What does this mean? What does that mean? And then you gotta hand over your phone and all your text messages, which is very intrusive. And some things you may not want out there are then revealed. And you have to sign immediately. Film companies are notorious for doing this. Hollywood's notorious for doing this. Larger companies, like again with that photography example, are notorious for doing this in sending you a contract and giving you less than 24 hours to sign. And it really, really frustrates me. It's not fair. It particularly happens with filming a lot, because the filming schedules are, if you're gonna do something that's gonna show up in a TV show, the filming schedules are just so tight and so stressed anyway. The last thing that they do is think about, oh, we gotta get clearance and permission to use all this artwork. So, and then they just send it to you at the last minute, giving you no time to look at it, no time to talk to an attorney, no time to just digest it yourself, no time to negotiate, any of that. And in those situations, something to think about is, I have a decision of, if I go forward, I'm likely potentially losing some major rights here, but is that worth what's getting exchanged, the exposure, and things like that? Do you think? And sometimes it isn't. And a lot of times it isn't. A lot of times, even though there's an opportunity there and they give you this contract at the last minute, the likelihood of that really boosting your career may not be there. So it's a really hard decision to make. You can push back and say, no, I want a couple days. I've got to talk with my lawyer. That's very reasonable. But sometimes in those situations, they're on their own deadline, and you're sort of, it's one of those, do I want this deal or do I not? If it's not like a rush in one of those situations, there should be time. You should be able to have time to sit with it, Sitting on a contract, for a week or a couple weeks to think about it, that's pretty reasonable. And there could be a lot of back and forth too, what you want changed and not changed. And, timing for me, usually when I get done reviewing a contract and making changes, sometimes I'll get comments, I'll send it off, and sometimes the other party will get back to me that day or later that day, but sometimes they'll get back to me 2 weeks, 3 weeks, a month. It kind of varies sort of what the timing is of the project involved. You have a right, if they're forcing you into a contract, if someone's trying to force you into a contract and not give you the reasonable time to look at it, they could be also, essentially a little bit of coercion there as well too, like you not understanding what you're signing. And not being given time to sign that as well. So that's another red flag. If it's getting a contract signed quickly because there's some kind of pressing deadline, that's one situation. But if there's not that pressing deadline, take time, sit with it, think about it, call people, discuss it before you sign. Okay, so contract building blocks. So most contracts usually have this sort of layout. There's going to be the title of what the contract is. Then there's going to be a description of the parties signing, like who's the names, addresses. There's going to be the effective date, so when the contract is in effect. Typically, you'll notice that in contracts there's going to be like capitalized words that are randomly that shouldn't be capitalized. When you see that, that means there's been a special definition attached. So there's typically, it'll be like artwork in this contract, capital A, artwork, and then artwork means this sculpture that you're doing at blah, 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 blah. So when you see sort of these random capitalized words that shouldn't be, right, in normal grammar, it's because there's a specific meaning to that than just the common meaning that we all know. So that's typically then the next part of the contract. Then there's going to be the length of the contract. Usually it's like it ends when maybe the project's completed, or if this is an ongoing relationship with someone, could be a year or a 2-year thing. Termination of the contract, how you can get out of the contract, and how the other side can get out of the contract. The scope of work and services, which I should have highlighted this. I think this is one of the most important parts, is the accurate description of what you're doing, and making sure it covers everything you're doing, and making sure there's not things described in there that you don't intend on doing, right? And being clear and specific about that. Saying you're hiring me to create artwork, but not describing it or anything more, that's not enough. Like you've got to kind of add some specificity. Payment terms, how you're getting paid, when you're getting paid, if it's being broken up into different payments, installments. Representations and warranties. For artists, typically, this means you're representing, it means you're promising, you're giving a warranty. Like when you get a car and there's a warranty for it, right? Or you buy you're giving a warranty about your artwork. Usually for artists, what it is that you're warranting and promising that's an original work of art. So they don't have to be worried about it's a copyright infringement issue. Or if sometimes like with a public work, like your warranty, it's like gonna be in a good condition for a year. It'll stand up. For a photographer would be like it's an original work of art that you've created. Yeah, that's typically, that's usually what, it's more when it's something, with sculptures, we typically see a warranty of that it's gonna not be damaged or break down or have defects for a period of time. This word that I hate, that's really long and complicated, indemnification. I'll talk about that. A short way to remember that is you're going to pay for the legal costs for someone else. So, and then there's usually a limited liability clause that sort of talks, limits like how much you would have to pay or how much the other side is going to pay in a contract if it gets broken, if it's breached. Choice of law. We're here in Texas. Someone could hire in another country or another state to do something, and then they'll say, by the way, this contract is under New York law. So that means, New York has its own set of laws, Texas has our own set of laws, England has their own set of laws, right? You would be bound, whatever, if there was a dispute, then you're under that area's laws, and that can differ vastly. Like the protections for artists in France are obviously much better than the protections for artists here in the United States, so it can differ. And then venue, think of like an event venue, like think of it as a place. So this is if you guys got into a lawsuit, where that lawsuit would have to be filed. So let's say you're hired for something in New York and it has New York law and it says all disputes are New York. Guess what? You got to go hire a New York lawyer. And the lawsuit will be in New York. It wouldn't be here in Texas. But that's just something to sort of be aware of, like when you start working if you're working on a national basis or an international basis, you could be under some other country's laws or the lawsuit would have to be brought in some other place. All right, so contract terms I want you to know about is this transfer of copyright again and the work for hire. So knowing, if you're giving up those rights. The ability to terminate the contract. For example, if you're being represented by a gallery and you're nervous about that representation, and you're not happy with it, what if the contract says you can't get out of it at all for 2 years, right? So then you're stuck. So you would maybe want an ability of things aren't going so well, so 60 days. If I'm not happy, I'm gonna give you 60 days notice and I can get out, right? And it could be even sooner, for other projects, maybe you want it 30 days if you're not happy and things like that. What is your ability that if things don't work out, how can you walk away from the situation without being sort of stuck? What are the remedies if you're not getting paid? Something I always like to add on this is that if someone is late paying you and you can't get them to pay, if you've got to call me or call someone to help you collect, they're going to have to pay for those legal fees. That's not fair. That's not fair that you had to incur costs to go get money that's owed to you. So I like to include language that says, okay, well, but if you're late paying me or I can't get paid and I have to hire anyone to help with collections, those are costs you're going to have to pay me on top of the late fee. Or maybe interest. You can add interest too, right? If you're 30 days late, guess what? You're going to start paying me interest instead of reasonable interest rate. What laws apply and where a dispute is handled. This is more of an issue if, like I said, you're working in other states and you're working internationally, where making sure that perhaps you're going to want it here in Texas, any disputes to be here in Texas, because it's your home turf. It's much cheaper to get a lawyer here, much easier to, you don't have to fly around to go to court hearings, things like that. The scope of the work you're providing, again, I want it to make sure it's clear and definite and it's very, if I walked in and me not being a lawyer at all, no legal experience, would I be able to read your scope of work and understand what you are doing? Deadlines and milestones as well. Are those reasons, if it's a project that's going to take a longer period of time, making sure those deadlines and milestones are reasonable for you and you can make that. But also think about some wiggle room if say there's a supply shortage and you can't finish the project on time. Be able to reasonably move those deadlines based on something that's outside of your control. Okay, indemnification. So this is a contract. Essentially, someone is hiring you to do something, a project, and if this company that's hiring you gets sued or incurs legal fees for something you did, they want you to pay them back for it. Okay. These come again in all shapes and sizes. This is an example here that's very broad, and that essentially the artist is going to have to pay for any expenses to that company for any legal fees or damages and things like that they get from the act of the artist, right? You'll see these a lot in contracts. You can actually ask for what's called mutual indemnification, so it goes both ways. And that's pretty common to ask for, and that's reasonable to ask for. Okay, but I have to get sued for what you do. I want you to pay me too, right? That's not fair, it's just one-sided. So if you see this word indemnification, it means they're asking you to pay their legal fees if you do something that causes them to have these legal fees or costs. And again, you could ask for that reverse as well to protect yourself too. That's a good question. So contingency is typically, like you said, it's in the reactive situation. There's been a lawsuit. Most lawyers will not do the proactive because there's not a winning thing. There's not a pot of money at the end of the rainbow, right? There's not a legal damages or a judgment, right? So when you're dealing with the proactive, hey, I want to get my own contract done for my commissions. I've worked with a lot of artists on getting their own commission agreement done, or want to get my copyrights registered, things like that. So lawyers will work. You're going to pay for their time hourly. Either a lot of them do flat fee, So like they'll quote you, okay, this is going to be the cost to put that contract together. It's going to be a flat fee. So there's no surprises. However long it takes an attorney to put it together, that's on their end. If they're efficient or not efficient, that's on their end. But this is the no hidden, you know what you're going to pay. And that's also a lot of attorneys will do. You can ask for a flat fee. And for templates, like so you get your own contract template, most attorneys will agree to do that on a flat fee. And then for copyright registrations, a lot of attorneys will agree to do that on a flat fee. Trademark, we haven't talked about trademarks at all, which are, think of like company brands, slogans, logos, right? Those are filed typically on a flat fee basis too. When usually the attorney asks for an hourly is when there's going to be like a lot of negotiation. There's things they can't control. So if we're going to go back and forth and back, like if I'm representing an artist and this artist is about to do a retrospective of a museum, okay? There's going to be months of back and forth and go, you know, I don't know how many emails I'm going to have to answer. I don't know how many times I'm going to have to rewrite the contract or revise it. I don't know how many phone calls I'm going to have to get on things like that. That you do as an hourly. And then usually what the lawyer does is they'll ask for a deposit. So based on how big things are and how complicated it is, we try to take that deposit and then that's what we'll bill our time from. Okay, and this is how I work. I can't speak for others, but I try to make that deposit as sort of an accurate estimate of what I think it will actually cost. And if I have money left over, you get that back. Or sometimes the client just says, keep it there, apply it to the next situation that we have. And so that's usually how you work on an hourly basis is, and then like with flat fees, like sometimes I'll either require the payment up front or I'll break it into payments and do payment plans. Something to ask is, can you do this on a flat fee? Always ask that, you know, is like this specific contract or something, or maybe the copyright registration on a flat fee, can you do that? And then that way you, there's no hidden surprises. You know what you're getting. You can budget. Yeah, you can budget for that. Okay, so someone is taking your work. What do you do? So typically what you first do is send what's called a cease and desist letter. That was the letter I was describing earlier with the photographs, okay? And the cease and desist letter, and I even like, one client right now has so much infringement going on, it's really expensive to have me do it all. So I'm setting them up with a template letter with like, fill in this blank here and describe, trying to help them so they can kind of, and then I can just sort of do a once over real quickly just to make sure, sort of help them, you know, handle these cease and desist letters going forward. You know, they can't put my letterhead on it because I'm not sending that. But the cease and desist letter, that's going to describe the artwork. You know, hey, look, I found that you're stealing my stuff. Here's images of where you're stealing it. You know, always save what you find, because a lot of times when people get these letters, they immediately delete it and be like, poof, it's gone. So before you send that letter, you have to make sure you've got all the evidence saved and archived, because it'll disappear. And it describes like what they've done. Here's some images. I caught you doing the bad thing. And either you can ask them either or in both, stop doing the infringement immediately and pay me money. Or maybe the situation is you just want them to stop, okay? So when they get those letters, what you can't control is if they react to them at all. You're just sending a letter. It's not a lawsuit. In a lawsuit, you have a legal obligation to respond to a lawsuit. When you send a letter, you don't have a legal obligation to respond, to get a response back. So sometimes these cease and desist letters are helpful, and people will listen to them. They'll get scared, and then they'll like, okay, this person's being serious. But a lot of times there is just no response, so know that. What I think is really powerful is the takedowns. So say you send a cease and desist letter and they don't listen to you. And you can see that they are posting your artwork on their social media account or on Amazon. They're trying to sell it on eBay or Amazon. It's on Pinterest, Etsy, things like that. Well, all these platforms, TikTok, Twitter, X, whatever he's calling it now, Instagram, Facebook, they, by law, have an obligation to create an ability for you to report infringement, and they have a job to enforce and police things that are going on their websites. If they don't do that, they get fined a lot of money. So there's an incentive for Facebook to take your takedown notice very seriously. And what it is so they have, you Googled like Facebook copyright infringement or Instagram copyright infringement, you're going to see that you'll get taken to a part of the terms of Instagram that'll say report copyright infringement. And there's like a whole portal. And it's like you copy the URLs and give them snapshots and describe you as an artist. Now, something to know is that sometimes some of these platforms require you to have a registration of the copyright to do that, or an application on file, okay? But not always. And you can do this for trademarks too, like if you've got a certain brand name, you can do that too. So they'll get the notice and they have to take this very seriously, and they will shut down the account like a couple of days. And getting your account back is really, really hard, really hard. So it's very powerful because maybe they won't listen to you, maybe they won't pay you money, but you're shut down the Instagram account where they get all their sales, right? So, but these takedown requests are super powerful. So if they're not going to take you seriously, like Instagram has to take it down. So, and then there's a lawsuit. The lawsuit should always, always, always be the last resort, you know, or it's just a really big emergency situation. Lawsuits take years. To the extent that we can resolve things with takedown notices and with phone calls and emails and trying to mediate and talk, like that's the route to go versus just jumping straight to the lawsuit. Because once that lawsuit train starts, you can't stop it. Like legally, there's things that have to be filed and done, and those are expensive. So, next slide. Okay, this is the last one. Okay, don't make these mistakes. Not signing a contract. Commission agreements, work for hires, your license agreements. The sale of the artwork, typically that's just like a bill of sale, right? Like, but they're going to usually, a lot of your collectors and clients are going to want a certificate of authenticity as well too. So that's usually included in that. Representation by a gallery or a dealer. Don't forget your copyright notice. Put that on as much as you can to the extent that you can. And just ignoring your rights and ignoring infringers too. The more you ignore it, the harder it's to police. And then when it gets really bad, it could be hard for you to assert your rights at that time. You only have a certain amount of time to file a lawsuit against someone who infringes your artwork. You've got 3 years, so from when you've noticed it and when you should have reasonably noticed it. So if you miss that time period, there's nothing you can do. So you can't just sit on stuff too as well. So your rights are really important as an artist. Like I said, there's a whole body of law just to protect works of art. So, so government takes it seriously, lawyers take it seriously. So there's me. This is me. You can see me at the Cedars Union here. Any other questions I can help with? You've got me here.